Welcome everybody to today's webinar. My name is Paula Price. I'm with the People's Law School. Today we are presenting on acting as an attorney or a representative under a planning document. And we have three amazing guest speakers with us today. They are Carrie Branco, Andrea Frisby, and Samantha Russell. I'll be introducing them more formally in just a few minutes. So just a few housekeeping items. If you have questions about this topic, you are in the right place. What you can expect today, we have 60 minutes together. We will be answering questions, your questions that have come in about representation agreements and powers of attorney and your roles being appointed under each of these. What you will learn is legal information, not advice, current as of today. So if what you're looking for is legal advice, which is the law as it applies to your particular set of circumstances, we would encourage you to seek legal advice. You're welcome to reach out to one of our speakers. Their contact information is on this screen. We would like to acknowledge we are grateful to work on the unceded traditional territories of the Musqueam, Squamish, and Tsleil-Waututh nations, whose people continue to live on and care for these lands. We would also like to thank our funders, the Department of Justice Canada, the Law Foundation of British Columbia, and the Notary Foundation, whose financial support funds these webinars. And finally, last but not least, we would love to introduce our speakers today. We have three of them. I will start with Andrea Frisby. Andrea is a lawyer with Legacy Tax and Trust Lawyers. She is a lawyer who practices in this area. She assists clients with estate and trust planning and administration. So she prepares powers of attorney, representation agreements. She gives legal advice in relation to the administration of estates and trusts. She's also an author and a speaker on this topic, and we are so thrilled to have her here today. Welcome, Andrea.
Thank you.
We also have Samantha Russell. Samantha is also a lawyer at Legacy Tax and Trust Lawyers. Samantha also works in this area. She helps clients prepare wills, powers of attorney, representation agreements, and other estate planning documents. She helps executors administrate estates, and she applies for probate. And we are delighted to have Samantha here with us today. Welcome, Samantha.
Thank you.
And finally, we have Carrie Branco. And Carrie Branco is the regional lead of the Advanced Care Planning Program at Fraser Health Authority, and she has been for the past 16 years. She has authored a number of chapters in various works on this topic, and she is also a clinical instructor at the UBC Department of Medicine. We are delighted to have Carrie here with us today. Carrie, welcome.
Thank you.
Thank you. And with that, we are going to jump into today's questions, starting with Andrea. Andrea, what is a power of attorney and what powers does that document give to an attorney?
So simply put, a power of attorney is really a document. So what it is, though, is probably the most important document in your estate planning arsenal of documents, because it's a document that permits an adult or a person to appoint another person to act as their legal and financial agent. So this is a document that you would make while capable to be able to say, okay, who would be able to assist me with finances if in later years I start to lose capacity. So it's a very powerful document. We put lots of different powers and bells and whistles into the documents that might allow you to appoint an agent to settle a trust on your behalf, to make charitable gifts on your behalf, pay your bills, deal with your land, these kind of things. Without that document in place, you can have a gap in who can make a financial decision for you if in the future you were to lose capacity. So we make powers of attorney that are called general enduring powers of attorney usually, which means that they become active when they're made. And then this power to be a financial agent for the adult who's appointed to you can continue on if they suffer from a subsequent incapacity, aging, illness, that kind of thing. So we also, we will craft these sometimes. So you can have a very simple document that just literally appoints the agent and says they can do things, or you can have a very bespoke document that allows for what I call superpowers. So one of the superpowers that we'd put in would be maybe to settle a trust on behalf of the adult, and also to give a power to benefit. So we often will see, if you have an aging a parent, for example, who has a child with a disability, we might want a power of attorney that says, hey, if I'm alive, I want the ability for my agent to use my money to benefit my disabled child during my lifetime if I'm incapable in the future. So it's powerful contractual arrangement, I guess, which is for you to organize your affairs.
Beautiful. Thank you so much, Andrea. So some of the takeaways I have from that are legal and financial, prepared while capable, and giving all sorts of different types of authorities depending on what is provided for within the power of attorney.
That's right.
Beautiful. Thank you. Samantha, this next question is for you. And the question here is, what is a representative agreement? What powers does it give a representative? And what kind of decisions does a representative need to make?
Yeah, so a representation agreement allows an adult to appoint someone to have the power to make decisions about their health and their personal care decisions if the adult is unable to make those decisions themselves. So this can go anywhere from like deciding who the adult's going to live with, the nature and extent of the adult's clothing, nutrition, hydration, exercise, whether or not the adult's going to be physically restrained, moved, or managed, all the way up to refusing or providing consent about major surgery or end of life decisions. So this is a really important role. And if you've been appointed in this role, this person has imparted a lot of trust on you, and there are certain provisions that may or may not be included in your particular representation agreement. So it's a good idea to look at the representation agreement before you're having to act. So for example, the adult can give the representative the authority to make arrangements for the temporary care and education of any minor children they might take care of, or make decisions with respect to their religious practices. And those are specific things that would be listed in the document themselves. So many of these types of decisions can be really, really difficult when it comes to that time to make those important decisions. So I do recommend with my clients that they have open conversations with their representatives. These are really difficult conversations to have, and they can be very, very overwhelming. But when you are making those decisions, it's better to have an idea of what the adult believes, what decision they would want made in that situation, because that's really the decision that you should be making. So if you come up against a decision that you have no idea what the adult would want, what you need to take into account is the wishes that the adults express to you while they're capable, whether their condition is likely to improve based off whatever decision you're making, and the sort of like a risk benefit analysis for them.
Beautiful. Thank you so much, Samantha. And there's a typo on my slide, representation agreement, and it is the representative under that agreement. Thank you.
Yeah.
And here we're talking about those, as you described, the health and personal cares, and you talked about beliefs and values. And so it's a different set of decisions that will be made on behalf of somebody else. Carrie, this next question is for you. And here we have someone who wrote in, they said, how do I know if I've been made a decision maker under a representation agreement? I'm trying to figure out if I can make medical decisions for my uncle.
Yeah, great. Thank you. These questions are so good. And before I get into this, I also wanted to mention that the language that we use across the country does differ. And so sometimes when we're talking about this, it is a bit challenging. I think I saw anyways that we did have a few people here from different provinces. So just to bear in mind that this language we're using today is BC specific based on the laws. So how do I know that you're a decision maker? Well, great question. So certainly, again, I come from that health authority and health organization lens, but I certainly know, as Andrea and Samantha have also said, in the legal community, I think we all really tell people to have conversations. And so how do you know? Gosh, I really hope that it's because you've had conversations and you've had some conversations about what's important to this person and the kinds of decisions they would want you to make if they were unable to make their own decisions. Because that, again, as Samantha said, that really is your role. And it's not one conversation, it's usually many conversations over many years. You know, in an ideal world, these kinds of conversations should start when we're younger and when we're healthier. So Fraser Health follows a national framework to advanced care planning, where we really say there are 5 steps to advanced care planning. Doesn't need to be in any particular order necessarily, but think about what's important to you. Learn about what's going on with your health if you have some health conditions, and you should be journeying along that with the representative and other people actually in your life who will be there to support you, to decide, which is what this is, who would be a good person to make decisions for you. Not everybody's actually fit for this role, much like not all of us are fit to be powers of attorney and look after people's finances. Not everybody wants to take on this role. So it's really important to have those open conversations and to really talk. And that last piece we talk about is recording. So again, I go back to how do I know? Well, because you've had some really good conversations. And also because this is a legal document, there is some signing. So hopefully you've actually had to sign out there, and so you would actually know that. Certainly to prepare for this role, again, we've got some workbooks out there in the health authorities and in the province that really help with guiding those steps. Because sometimes the conversations aren't necessarily difficult; they're just hard to get started, and it's hard to know actually what to start with and what to ask and how to have those conversations. So I hope that answers that question.
Yeah, that's really helpful, Carrie. And one of the key things this individual would want to know is, did they actually sign something? It sounds like you can't just be made a representative without your knowledge. This is something that you would know, and ideally have been involved in a number of conversations leading up to that point.
Exactly. Hopefully Andrea and Samantha are saying yes to that.
Everybody's nodding their heads. Everybody's nodding their heads.
This is a good sign. This is a good sign.
Yes, we're on the right track. This next question is for you as well, Carrie. And
okay.
This one is, my father has dementia and his condition is getting worse by the day. My siblings and I want to move him into a care home where he'll have better support. He refuses and wants to live independently, but we worry that something will happen to him. I'm named as his representative in a representation agreement. At what point can I make the decision for him to move into a home?
Right. Well, these are challenging situations, aren't they, out there in our families these days? I think that when I read this, I think, gosh, don't we all want our families and those that really matter to us to be safe and to get the support that they need? However, we also have the right to live at risk, even though the rest of us in the family might not like that very much. So as long as he is able to, make his decisions in terms of being capable to make those decisions, that is his decision to make. In British Columbia, all of the health authorities have great home and community resources that can help this gentleman, hopefully live as independently as possible. At what point can you make the decision for your dad or another loved one to move? It's very situational, so it's really hard to say, well, this is the time or this is not the time. Again, I think that's why it's really important to involve your physician if you have one, your nurse practitioner, and to involve the health authority around that home and community piece and what services can go in there. Again, I think Samantha talked about that too. It's that weighing that risk and benefits kind of analysis. When I read this question though too, it made me think of a book that I've read and that I would recommend, and the author is Atul Gawande, and he's a physician from the States, and it's a book called Being Mortal. It's been out for a number of years now, but he actually speaks about this area of having, assisted living facilities and long-term care facilities and sort of the safety nets that we put around them, which are great. But I think it's interesting to listen to him speak about the history of those kind of facility institutions and again that sort of that idea of safety that we as families maybe need to have a little bit more self-reflection upon. So I would certainly, that's a great book for everything else, but that particular chapter resonates with me as well.
Thank you so much, Carrie. And I think that just highlights that there's your legal right to do something, but also the personal and relationship, what is best for the person type of analysis as well. And that sounds like a wonderful book. We will provide a link to that when we do the recording of it might be in the chat. I can't see the chat right now. But we'll put a recording of, or a link to that along with the recording of today's webinar for anybody who would like to look into that further.
Wonderful. Thank you.
Thank you. The next question is for you, Andrea. In 2001, I was appointed power of attorney by my husband. This was done through a lawyer. Are there steps that I need to take before putting this into effect?
Well, again, I think I'm going to keep saying you have to look at the document first, because the powers are they're really contained in the four corners of the document. So a power of attorney that was made in 2001 would have been made under the earlier version of the legislation. So the first thing you would do is to take a look at it and make sure that it's properly signed by the husband, who would have signed that in the presence of a BC lawyer or notary. At the time, the attorney didn't have to do a matching signature, which is not the case now. So a valid document that was done today would have the adult signing and the person who's appointed signing as well. You would have to look at the terms of it, make sure that it's the general enduring power of attorney. So make sure that it was supposed to last through an incapacity, which it probably would have been. And then you would also expect to find possibly a declaration like attached to the back of that power of attorney that may or may not have been filled in by the person appointed, the wife at the time, that would say, if I'm going to help with land, so if I'm going to deal with the house and the real property, then the person would have to attend in the presence of a lawyer or a notary and do a declaration for land title purposes that would show that the wife was over the age of 19. If all of those components are in place and you're looking at a valid document, then the wife can totally start acting. There are some duties and responsibilities when you start acting as an attorney, whether it's for a spouse or a family member or a friend even, and those are set out in the Power of Attorney Act. But like in a nutshell, what they are is when you're acting as an attorney, you always have to act in the best interest of the adult that you're helping. So in law, we call it like a fiduciary role, but in real life, we just call it making sure you're acting for like in the best interest of the person that you act for, that you're agent for, and that you're not doing anything that's helping yourself over their better interest. So the legislation has some little rules about keeping track of assets when you start acting. So it's a little different for husband and wife because they very often have joint assets. But when you see someone coming in to act for a parent or a friend, you would want to make sure as the attorney who is starting to act that you take a snapshot of the finances when you come in, that you take some lists of documentation that like shows what the adult owned, where it's kept, and then if you do any transactions, you move any money around, that you keep records of that. So you as the attorney, as the fiduciary person, can show like the world, yes, I'm doing a good job and I'm acting only in the best interests of this person that I'm taking care of financially.
Beautiful. Thank you so much, Andrea. One of the things you mentioned yesterday when we were doing prep for today's session was that you sometimes act on the behalf of a representative or an attorney under a power of attorney. So I gather that if you have questions about what it is that you're allowed to do, that you can do, questions about how to create an accounting when you first start out your role, that is something that you could go and seek some legal advice on so that you know that you're moving in the right direction. Is that correct?
It is. And actually you see quite a bit of, at times there's quite a bit of action in that kind of area, I guess. It's the sort of, that zone where you have somebody starting to become incapable, but maybe not completely incapable because it's not a bright line, and a family member or the person who's appointed being like, oh, I think I need to start acting. Should I start? Like, do they need me to protect? How do I do that? So we do see lots of clients who need advice to walk through that piece because it can be quite difficult, like saying to a mom or a dad or a friend, actually, I don't think you can cope with your finances anymore. People get ornery, and that navigating that piece while protecting them because they've also become vulnerable is real.
Yeah, beautiful. Thank you so much, Andrea. This next question is for Samantha. And here, Samantha, we have a situation where my husband had a stroke, and for now, is unable to read or sign his name to any documents. How do I become an attorney under a power of attorney for him?
Yeah, so there are a couple layers to this question. So the first that I'll speak to is the issue of capacity, or in other words, the ability to make a power of attorney. And the second is whether or not someone can make or appoint an attorney if they're unable to read or sign documents. So first, to make and appoint an attorney to make decisions on your behalf, this person's husband would have to have legal capacity. Now, most people aren't aware, and I was not aware until I started practicing in this area, that there is a distinction between legal capacity and medical capacity. So despite her husband having had a stroke, it's possible that he could have legal capacity, depending on the severity of his condition, to appoint his wife as his attorney. So to have legal capacity to make a power of attorney, the adult must be capable of both making decisions about their own financial affairs and understanding the nature and consequences of making or revoking the power of attorney document. So generally, legally, adults are presumed to be capable of making these decisions and of understanding the nature and consequences of those decisions. But particularly in this scenario where the person's recently suffered a stroke, the lawyer would have to be very, very alert to their duty to assess that person's legal capacity. So what does legal capacity mean? So from a legal perspective, for the adult to be capable of understanding the nature and consequences of the power of attorney document, they need to understand the property that they have and its approximate value, the obligation that the adult would owe to any dependents they have, that the attorney can do anything the adult could do with their financial affairs, and that if the attorney doesn't manage their property properly, it could decline in value, that the attorney could misuse their authority, and that the adult can revoke the power of attorney if they're still capable. So if after assessing capacity in this question scenario, it was determined that the client had a diminished level of capacity, there is still another option instead of a power of attorney, and that's to do what's called a Section 7 representation agreement. So this type of representation agreement could allow his wife to make decisions with respect to sort of routine management of his affairs. It requires a lower standard of capacity than a power of attorney, and it's assessed on factors such as whether the adult communicates a desire to have someone else making decisions, whether there's a relationship of trust between that person and the potential representative, and whether they're able to demonstrate preferences or choices. Now, in this scenario, if the client does not have capacity, his spouse would have to apply to court to have a determination of incapacity made and be appointed as the comity of his estate. And that would give her the ability to make financial decisions on his behalf. Now, this is one of the reasons why it's very important to have your incapacity planning documents in place really early, because this process is expensive and lengthy. It involves getting 2 affidavits from a doctor confirming that the person is no longer capable, and legal fees are always a treat as well. So essentially, it's good to get on that early. I can't go into more details on what becoming appointed as a committee looks like in today's presentation, but if you want to reach out to me after by email, I'm happy to provide you with more information on that. So the second piece of this question is whether the person's husband, if it was determined that he did have legal capacity, could still appoint an attorney if they're unable to read or sign the document. Now, it's really important to recognize that a person's physical ability to sign their name is not indicative of their legal or mental capacity to sign. Many people suffer their entire lives with physical disabilities, which may prevent them from signing documents, but they nevertheless have the legal and mental capacity to understand what they're signing and give informed consent or agreement. So with respect to signature on a legal document like this, what's important to consider is the intention of the person who signs or wants to sign the document, and not necessarily the method used. So for example, another alternative to a written signature is a mark. So an X, a thumbprint, a toe print, whatever really, as long as somebody witnesses someone doing this and swears an affidavit saying that they witnessed this happening, that will be a valid appointment. So in summary, the scenario presented here is a little bit complicated, and there are some layers to look at. But first, you'd have to determine whether the husband was capable of making the document despite having the stroke. And if they did have capacity, that an inability to read or sign the document would definitely not prevent them from appointing his wife as his attorney.
Beautiful. Samantha, thank you. Such a wonderful answer that you provided. And I do believe your colleague, Cheyenne Reese, spoke at a webinar last year about powers of attorney, and I believe that she may have talked about committeeship in that webinar. So there may also be some information there for anybody who is looking for more, in addition to potentially reaching out to you as well. So thank you so much for that. And I also appreciated your different levels of capacity. So the idea that the power of attorney will require one level of capacity versus representation agreement to the Section 7, where it's a lower level. So just explaining that was really helpful. Thank you. Next question. So this one is for Andrea. And here we have a situation where we have an 83-year-old who is the attorney for a friend who lives in a care home. That person is concerned that she will become incapable of looking after her friend, or that the friend will outlive her. So she has a younger friend who is fond of the friend and willing to take over the power of attorney if necessary. Is there a way to legally empower this younger friend to act?
So, again, this is like it's one of those things that's better done at the planning table rather than the like, oh no, what are we going to do now? So I guess my first question is, the 83-year-old, the friend who lives in the care home, does she have capacity? If she has the capacity that Samantha was speaking about, like to understand or to make a power of attorney, then she could make a second layer power of attorney. So at the planning table, we will often do primary and then a second or third layer to deal with this kind of what happens if somebody ages out of being able to act. If the friend who's living in the care home cannot make a document anymore, so she lacks the capacity to appoint a successor, then we are really going to have to look at the document at the particular power of attorney and see if it has one of those superpowers that I was speaking about, which would be a power to delegate. So quite often people will put a power to delegate in the power of attorney, which means that the agent can appoint an agent to do what they would be able to do. If that is not in there, so you're strictly within the four corners again of the document, and the 83-year-old friend just can't go ahead and appoint somebody else. And if you need someone else to be appointed, you're sort of looking back at like what could be done. Is it possible to do a Section 7 representation agreement to deal with just the sort of day-to-day financial matters and other sort of health and personal care issues? Or are you looking at the committeeship, which is the formal application to the court, which is going to require 2 affidavits from doctors that say this friend living in the care home no longer has capacity, like medical capacity? So back to the planning table, I think, is like when people are making these plans is to sort of like spend the time and maybe a little bit more money to think about the what ifs, and if possible have a primary power of attorney, so maybe husband and wife, it's each other, and then appoint the kids with some mechanism or some promise or trust to the kids about when they're going to start to act.
Beautiful. Thank you so much, Andrea. This next question is for you, Carrie, and the question here is, what are personal care decisions and how do they differ from healthcare decisions?
Thanks for that question, but I can't help to say, does everybody just want to go run and look at their power of attorney and see if there's that clause in it? Because Andrea, I was like, every time I do one of these, I learn something new. I know I've got a secondary and third in there, but oh no. Anyways, and I just also wanted to reiterate something that Samantha has said several times and Andrea has also said and reiterated, and that is that planning, whether it's for your finances or whether it's for healthcare, really should begin earlier. And I think this is a challenge that we all have out there. Those of us who are in this work, be it from the medical side or the legal side, I'm sure are hounding our families and friends all the time saying, get this done. So just a plug to say, yes, this is really something we should do when we're younger and when we're healthier. Wouldn't it be nice if it was attached to buying a house, or maybe that's not a good example these days, renting a house, getting a driver's license, something like that. So I think Samantha actually addressed this right in the beginning, but just to reiterate a little bit around personal care and healthcare decisions. So those personal care decisions are things like what people eat, how they dress, what activities they participate in, what educational institutions maybe they attend. So those, so the personal care decisions are the non-medical decisions. So the healthcare decisions tend to be lumped into, minor and major things. So blood work or, surgeries. So the healthcare are definitely treatment decisions. Dialysis also comes to mind. So those are the differences between personal care and healthcare decisions. I also wanted to reiterate something that I think Andrea has said a couple of times, and that is that these documents do differ, and so it's really important that you look at these and you say, well, gosh, maybe I would want my representative to make X decision in the personal care bucket, but I wouldn't want them to make Y. So I also think it's really important to be really mindful, whether you're making a financial power of attorney or the healthcare one, that you really are thinking about, do I really want this person to decide who visits me, as an example? If I'm unable to articulate that myself, or not. So I thought I'd also just mention that, but great question for sure, because there are differences.
Beautiful. Thank you so much, Carrie. And Samantha, as Carrie alluded to, you've touched on this a bit in the beginning. What can you do to prepare myself to make decisions under a representation agreement?
So the most important thing is to have those conversations. It can go anywhere from like knowing the person's values. So what they value day to day, what's important to them if you're being put in a difficult situation where they're not able to have something but have something else, all the way to sort of end of life decisions and how they feel about those decisions. It's also helpful to actually look at the representation agreement. Now you'll have to sign and accept your appointment, but it's good to be very familiar with what you're signing and just go through the terms of the agreement. Because as I mentioned earlier, sometimes the adult who appointed you might have given you an extra power in there that you weren't aware of. And so you might want to become more familiar, for example, with their religious beliefs or their caregiving practices, if you're going to be in charge of taking care of the minor child, if they lose capacity to do so themselves. So I would just say the most important things, again, are just talking to the person who's appointed you and making sure that you take a look at the document, because as we said, they're not boilerplate documents, so they can vary and have different powers in there. So it's just important to be familiar with them. I think these types of documents get pushed to the back of the shelf and hopefully we'll never have to use them, but sadly that's not the case. So it's just important to take a look at them in advance before you're feeling the stress of having to make those decisions.
Beautiful. Thank you so much. And I love that we have common themes that are emerging in today's session. This next question is for you, Andrea. Why are banks allowed to refuse to recognize a Section 7 representation agreement despite BC legislation?
Yeah, that's an interesting question, and I haven't seen it happen, which kind of made me wonder. But obviously, banks are regulated by federal law, so I'm not sure if that's part of it. But I would suggest that if someone has a valid Section 7 representation agreement that firmly and clearly prescribes that the Section 7 representative is permitted to assist that adult with day-to-day financial decisions, that you could probably poke the bank and find out why that is. Sometimes the banks have a head office that deals with these matters, and the head office is nearly always back east. And one of the things I've noticed people signing in, and Carrie alluded to it, is that the documents are really different in different provinces. So even for like a power of attorney, for example, there's no a power of attorney in BC is very territorial. So that's going to work for BC, for our land. But if you have land in Alberta or Saskatchewan or Quebec, then you're going to need to go to each jurisdiction and say, okay, what do I need to do to have a power of attorney and a healthcare or a financial decision maker in that jurisdiction? And it's the same for international as well. If you have like a nice little property in the States, or I don't know, somewhere warm and sunny like Mexico, you need to kind of figure out what happens for your personal planning there if you need a financial agent, and also maybe if you're going to be there for a long time, what to do if you're going to have a health crisis. I know I like straight off the question there, but I guess I would just, to answer this question, I would be like, I'm not sure that they can do that. So I would be asking them why they're not accepting the Section 7 and looking for their rationale.
Thank you, Andrea. That's very helpful. And yes, this is a question that comes in from somebody who had this problem. And so I think that's a really helpful and practical way to approach this. The next question is for you, Carrie. And here we have a person who says, I'm named as a representative under my parents' representation agreement. What if a family member or healthcare professional disagrees with the decisions that I make?
Thank you for that. If I can just jump back a little bit to that other question around the bank, one of the suggestions that we have in our healthcare system is to go proactively to the banks with any of these agreements, because we certainly have heard of this happening quite a bit as well. And I think somebody else made a comment. So proactively go and give the bank those powers of attorney and rep agreements, because they do tend to go back to Toronto, and then the lawyers have to look at it over there, and so it could take some time. Anyways, so you're named as a representative. What if there's some disagreements? Well, I think when I see this question, I think of, and Samantha talked about this, there are roles and responsibilities, as a power of attorney, and there's also roles and responsibilities, certainly as a representative. And so again, I would be mindful to, before you sign on the dotted line, know what you're signing up for and making sure that you are in agreement to that. Because much similar to a power of attorney, you need to honor what the person's wishes were. Therefore, that's why those conversations are important. And we also have that best interest language in this legislation as well. So just to be mindful of that. One of the things that I also wanted to point out was, in the healthcare system, we try very hard. I'm not saying we're successful all the time, but we also try very hard to have a shared decision-making model where we, really respect the person and their family, or those that matter to them, to really come to us and let us know what's important to this person if they're unable to communicate with us at the time, so that we have a really good sense of who they are. And bear in mind that, then we're coming with the medical expertise, particularly our physicians and nurse practitioners, obviously our nurses as well, with that medical expertise, and saying, because there comes a time when not all treatments, the benefits outweigh the risks. So we're doing this shared decision model all the time, where we're again honoring this person, but also needing to honor that there comes a time when some medical treatments maybe aren't sort of on offer and aren't actually beneficial. To the person. Not sure that, again, it answers this question 100%. Again, they're situation specific, but certainly from the healthcare lens, we really do try to do that shared decision, so that our disagreements, at least we can come to some common ground. So hopefully that answers that question.
Right. Well, that's really helpful. Thank you so much, Carrie. The next question is for you, Samantha, and we're back to the banks. The bank I'm dealing with refuses to accept an enduring power of attorney unless it's accompanied by a letter identifying that the individual has a cognitive decline. Is that legal?
So again, this does depend on the terms of the power of attorney. As Andrea talked about earlier, there are different appointments that you can make in terms of your attorney. So the attorney can either act the day of the appointment while you still have the ability to make your own financial decisions, or it could be a springing power of attorney, which means that you cannot act until they've lost the capacity to make those decisions themselves. So generally within the document itself, if you're not able to act until they've lost capacity, the document will stipulate what you need to have to prove that they have lost that capacity. So if there is something in the document that says you need 1 or 2 letters from doctors licensed to practice in BC confirming that they no longer have capacity, then the bank can ask for those doctor's letters. If it's what's called an enduring power of attorney, where you can act even if the adult's capable, they should not be asking for those letters. Now, having that language in the power of attorney document requiring the 2 doctors' letters can bring about a lot of delays, particularly when you're dealing with banks, as the wait times can just be exponential. So we tend to, at our firm, you can still have them, essentially, we just create enduring power of attorney documents so you can act as the day of, but we create a separate letter to the attorney saying, please don't act until I've actually lost the ability to make those decisions myself. That's going to be really dependent on the level of trust between you and your attorney, but I would expect that's a high level regardless, because you are appointing them as your attorney to make those important decisions. But yeah, anything that we can try and do to help out on our end, if it works for the client, to sort of get around those, that red tape with the bank is useful.
Beautiful. Thank you so much, Samantha. That's very practical and pragmatic answer. Samantha, we have another question for you, and this one is somewhat of a complicated situation. I'll describe it here. The person writing in, I'm the power of attorney for my mom. She's 80 years old and lives in a seniors facility. She owns a townhouse and wants to sell it. She has a granddaughter who lives in that townhouse and has for 14 years rent-free. She was asked to leave, but refused and was given a legal trespass notice. So she is suing her mom for the house and for its contents. What can I do? And what can the person in this position do to go ahead and sell the house?
Right. So the main takeaway for me in this question, just because I don't have a lot of experience in terms of sort of property law, and that's not really my area, or estate litigation. The main takeaway for me is just for people to be aware that the definition of financial affairs, so your ability to manage the adult's financial affairs, it does include their legal affairs. So this question isn't clear. I don't know if she was given a legal trespass notice prior to her mom losing capacity or not, or if the attorney has already hired a lawyer to assist her in dealing with this. But if there has been a claim made, I can't really speak with respect to the validity of the granddaughter's claim without more information. But I think the important takeaway here is just that you have the ability to hire a lawyer on your mom's behalf to deal with this situation so that you can sell the property and care for your mother properly.
Beautiful. And again, Samantha, I gather this would go back to the power of attorney itself. And would that be expressly provided for within the document, or is that something that is generally accepted to be a part of that power of attorney?
In terms of being able to sell the property, you mean the real property?
Being able to sell, being able to retain legal counsel to deal with the litigation?
Yeah, sometimes it'll be specifically in the document. It does also rely on that definition in the legislation of financial affairs, which breaks down exactly the authority that you're given. So sometimes it'll be specifically in the document, but sometimes they will just rely on that definition being provided within that document. So it would be unusual for you not to have the ability to make both legal and financial decisions, because they rely heavily in those documents on that definition that's found in the legislation.
Beautiful. Thank you so much, Samantha. This next question is for you, Carrie. And the question here is, our family is used to making decisions as a group. If a representation agreement is in place, can our whole family make the decision for our loved one?
I really like this question. It's one that we're faced with all the time. And I think for myself, anyways, I'll speak for myself. There are very few decisions I make independently on my own every day. I wish I could say that I get to decide what I'm having for supper all by myself, but I have a whole family here that I have to take into consideration. So certainly we have a lot of folks out there that have more than one person in their life who's important to them. We're often gaining information from other people, a neighbor, a close friend, a niece, somebody who lives overseas or anything like that. So oftentimes people are telling us information, and we're getting information from other people. And lots of families and communities out there make decisions collectively, and that's how they've done things. We still need, if the person is not able to sort of, we'll use surgery because it tends to be a simple one, sign the consent for surgery, then we would go to the person who has the representation agreement to sign the form. Don't necessarily need the whole family to sign that, but so I think in practice, how it works is that we're often having discussions with groups of people, and that's something that certainly we encourage, I think, in the healthcare system, is to make sure that we're getting to know this person as best as we can in the short, often times that we have that we're touching this person. So hopefully that answers the question. in terms of, lots of families do things by consensus, and sometimes they know they do know their loved one really well. And if there's it's hard to plan for everything, right? It's hard to say, well, this is exactly what I want you to do. So some things are left up for discussion. And I must say, in the healthcare system, we encourage people to come forward and have those kinds of discussions, knowing that there's roles and responsibilities, knowing we have to honor people's wishes, and not knowing those, we go with best interest. But yes, we certainly encourage that.
Beautiful, thank you. And I imagine that's quite helpful for the person who's ultimately signing off on the surgery to know that they've made that decision with the benefit of other family members who have had the chance to share their perspectives.
And oftentimes those other people are there to sort of say, yes, you're doing the right thing, which it's helpful for that person that has taken on that responsibility to be reminded of conversations and to be supported in those decisions.
Absolutely. So we have one last prepared question, and then we're going to turn to the live Q&A. So this one is for you, Andrea. As alternate power of attorney and representative for my father, do I have any rights to challenge his wife, who is power of attorney for him? They were married for 10 years. He has Alzheimer's, and she has been abusive toward him. He now lives with me.
So this is one of those questions with a few different layers. So the first thing you would do if you kind of got this call would be to ensure that physical and financial safety of the father are taken care of. So it sounds like the physical safety has been taken care of because he's now living with the person, the child. There are some provisions, and probably Kerry can speak well to this, that where you can make a report to the health authority if you're worried about elder abuse, and the health services will kind of look into that. There are also provisions in the Power of Attorney Act that allow you to make an anonymous report to the public guardian and trustee, which is the government body that kind of looks after finances for vulnerable people. So anybody, in fact, but as someone who thought that somebody was acting with a power of attorney like improperly, you could make an anonymous complaint or request for the PGT to investigate, and they would look into the actions of the wife who is acting as the power of attorney. Whether you can simultaneously act would depend on how the documents are drafted. And, whether you have like two whole powers of attorney that can act at the same time. So if the child did have one of those that's like a secondary but could come into being, then they could provide that to the bank and get copies of the transactions that are happening. But it sounds really like, my kind of feeling on that question is it's really looking to, is there harm going on here? And if there is harm, should it be reported and investigated by the government bodies? And, they will help the people make sure that there isn't financial abuse happening, essentially.
Beautiful. Thank you so much, Andrea. Turning to the first live question, I'm starting with one that had 10 upvotes. And Samantha, this might be a question for you because it follows on something you talked about. How do you determine when someone is no longer competent to make decisions for themselves?
Okay, so that can be a difficult question. As I was talking about, there's a difference between sort of legal and medical capacity. So if you're really not sure, you can of course go to the person's family physician, hopefully that's known them for years, and they can make that determination medically. You could also bring them into an appointment and we could do like sort of a legal assessment, ask them a variety of questions, but it's very difficult. So for example, if someone's been diagnosed with dementia, which is quite common, if they're having a lucid moment, they are able to appoint somebody to act as an attorney for them on their behalf. But again, it's hard to predict when those lucid moments will be. It's hard to gauge, when that's going to occur, and dementia can progress in its own time for each different person. So it's hard. I want to give you a black and white answer, but there's definitely resources and people that you can rely on to help you in making that determination, because it's also a lot more difficult if you know the person. A lot more difficult, but then again, you'll have a better grip on their normal capacity versus the capacity that they're demonstrating now. But I think it's always helpful to get more of an objective person, especially when those sort of emotional issues are going on. So I would recommend going to a family doctor or even reaching out to a lawyer and just chatting with them, and they could do sort of a legal assessment.
So, and Sam, I'm just going to jump in there because
Sure.
it sounds, because you and I work on this together sometimes. It's, you know, the legal assessment of capacity is like, it's nuanced as well. So if somebody has what we would call like kind of they have some deficits, then it's going to be more expensive because we're going to spend more time with them to make sure that we're comfortable. We might even get second lawyer into the meeting, and you know, we might ask for a doctor's backing us up. It's going to depend what they're doing really. If it's like very straightforward planning and we're very comfortable that we can meet with them a couple of times and they're giving consistent instructions, that's going to be a lot easier than if someone wants to do something a little bit wild, and then, you know, everybody's sort of things are going to go up and we're all going to be like really worried about capacity. Sorry, I couldn't help myself.
No, that's great. I think the more discussion, the better, frankly. I think it's great to hear different perspectives. This next question, and I think, again, Samantha, you may have already answered this. I'll just put it out there. As power of attorney, do I have full legal authority to sell the house if my family member is no longer able to look after financial matters and is in long-term care?
Yeah, so with the power of attorney document, you are going to have the legal authority to sell the house. With a Section 7 representation agreement that I was discussing earlier, where it's a certain level of capacity, but a diminished level of capacity, you don't have the authority to sell the real estate. Now, yeah, you just want to make sure that the reason that you're doing it is in the adult's best interest, that you need to be doing it, not because, you know, they're older and it seems more advantageous to you or other relatives. Like, you want to make sure that it is in the adult's best interest if you're deciding to do that, but you do have the legal authority to do that. And we often have attorneys signing on the adult's behalf to transfer property.
There is like a really funny twist in the Power of Attorney Act, though, that requires the attorney to think about what's in the adult's will. And if, for example, the will said, I leave the house to Fred, and the attorney, acting in the best interest of the adult, sells the house without realizing that, there are some kind of clawback provisions in the legislation. So if you are acting under a power of attorney and you don't really know what's in the adult's will and they really are not capable, you may want to sort of make sure there's not significant items that you're giving away or selling, even if you think you're doing the right thing, because it could come back and bite you in the estate administration.
Beautiful. Thank you so much. Here's another question. Is there a way that permits the representative to get paid?
Yes, it's unusual though. So in representation agreements, you would see that they're proper expenses. So if you spend money doing the job, you can usually be reimbursed for that. It's an option to put in a remuneration clause, but it probably requires some sort of application to court to have that approved or some discussion. We rarely see that. We do see it going into the power of attorney though. And if you don't have that in a power of attorney, then there is no mechanism for the attorney to be paid. So it's unusual in healthcare, personal care, because Carrie could probably speak better to it. It's kind of like an uncomfortable place where you're making a decision to keep someone's health extended because you're getting paid. It's funny, right?
Yeah, I mean, we don't see representation agreements too often, to be honest with you, but I certainly have some knowledge around that payment, and yes, I would say it's unusual.
Yeah.
Thank you. Here's another question, and Carrie, this might be one for you. How do you balance your loved one's autonomy against the need to ensure checks and balances are in place?
Yes, I know. I mean, I think in some of my answers, I tried to talk about that, and I encourage the book, right? Just to have us as family members who really do want to provide that protection and that support. But we also have to be mindful that people do have the right to live at risk. And I also think, which is why I mentioned, all the health authorities have home and community care, where we can have people come into your home. We have services where maybe somebody can go to a day program once or twice a week. That can really help to balance the life and to balance those risks. But it is a tough one. But I also think those are conversations that people should be having up front. And honestly, I certainly have had those with my own family around that. Right? I mean, where do you draw that line? And well, we don't know, but can we talk about where the line might be?
Beautiful. Thank you. I think we have time for one last question, which is an interesting one. It's prospective. Is it expected that when the MAID law revisions happen in March 2023, that the representative will be able to act as that final decision maker at the time of provision? I don't know if you have thoughts on that.
Well, from a legal perspective, no, I don't think so. So that, I mean, I think it's one of the most interesting areas of the development of the law is this kind of like, at what point do you lose the ability to opt into MAID yourself? And that's certainly something that, again, the health authorities are really embracing and looking into. From a legal perspective, you can't, it's one of those things you can't delegate. And I don't think you would see that. We might see some advancements though in how you can opt in to like the choice in the event of a future incapacity, maybe. I guess that's where you'd expect to see the most growth in that area. But even that is, probably many years away.
Thank you so much, Andrea. I might just ask each of you if you have anything else that you'd like to share today. And Carrie, you're top on my screen, so I'll start with you. Is there anything else that you'd like to share with our guests?
For sure. I would certainly encourage, I see that you have our Fraser Health website there. I certainly encourage folks to go to that. We do have a workbook that really helps, again, with those 5 steps. It's kind of a fill in, it's a PDF fillable, to really help to walk people through it, to walk through the steps of advanced care planning. And I couldn't help with that when you were speaking just a few seconds ago to say, how can we get this, get people to do this earlier? Any teachers on the line, retired teachers that want to go put this into the, career section of grade 12, 11 or something like that? That's always been an area where I think we can certainly grab the attention of our younger folks to have a new generation that actually embraces the financial planning ahead of time, as well as healthcare planning. They can help their parents and their grandparents as well as themselves.
Beautiful. Thank you so much. And Carrie, those resources are really helpful, and we will be, again, for the benefit of everybody who's listening, we will provide links to those resources on the web page that will ultimately host the recording of today's webinar. So thank you for that. Andrea, do you have anything else you'd like to share following on today's presentation?
Yeah, I mean, I suppose it's the same theme, which is, more discussion earlier, repeatedly as things change, because, the problem is the legal tools are really blunt and they don't really work very well in real life to deal with like those gray areas of incapacity. So, you have a document and it comes into force or it doesn't, but that doesn't really help when you're dealing with someone who maybe needs help dealing with the money to get their groceries, so the more discussion that you can have and the more open discussion about these issues, the better clients and people are going to be to like seamlessly move into the roles of assisting vulnerable people who need help.
Beautiful. Thank you so much, Andrea. And Samantha, we'd love to hear from you as well. And thank you again, all of you, Carrie, Andrea, Samantha, so much appreciate you being here today. And Samantha, I would love to hear your final takeaway from today's session.
So this is not really an overarching theme, but I was just thinking a bit about how we didn't touch on what a digital world we're living in now with respect to the power of attorney. So in terms of, password protected accounts online, any of that sort of information, we obviously do not recommend giving it to your attorney right away. That seems a bit risky, even though I know you trust them, but it should be written down somewhere and they should be able to have access to that information. It'll make things a lot easier for them, and eliminate more of like the red tape that you might come up against once they have lost capacity. So that's just a little takeaway that came to mind for me.
Beautiful and super practical. Much appreciated. So we are going to wrap up here. Thank you, everybody, and look forward to seeing you at our next webinar.